Hi, everybody. Thanks so much for being here today. As Kelly graciously noted that she volunteered to monitor the chat box, please feel free to ask questions at any time. It's very hard to make these interactive, but I think to the extent we can, it does make some of this material a little bit more interesting. So I'm here today to talk to you about the cessation of disability benefits. This is a topic that is very near and dear to me, and I know many people at CLS, and I'm guessing to a lot of you. And the reason is most clients that we have, SSI clients, will at some point face some sort of review where they may or may not have their benefits terminated. We spoke to many private practitioners over the years and confirmed that almost no private attorneys will handle these cases because it's very, very challenging to get fees out of them. And they take a lot of work. So that's not a knock on anybody, but it does mean that this is an area of representation where it's very important for legal services representatives to really show up, because otherwise people will be facing pretty significant legal issues without any representation. And I'm going to talk about all the issues that come up, but I just want to emphasize that from the beginning. Data from Pennsylvania and nationwide show that only about 5% of people have any representation when their benefits are being terminated before the state agency, Bureau of Disability Determinations, and only 17% get representation at all when they go to the hearing level. So just keeping that in mind, I'm going to share my screen so you can see my PowerPoint. All right. All right, so just 1 second here, sorry. So what causes Social Security Administration to terminate benefits? There's a couple things that you'll see a lot. The first one that is the main focus of today is continuing disability reviews. These are reviews of people to see whether or not they remain eligible for Social Security disability benefits. Another thing we're going to talk a lot about is age 18 reviews. This is an automatic review that happens to all child SSI clients when they turn 18. There can also be work-related terminations. So if the agency gets some sort of indication that someone is working and maybe working too much to get benefits, they'll be reviewed and potentially terminated. And also any other incident that would interrupt somebody's receipt of SSI for a year. So if you have a client that's incarcerated, if they are incarcerated for a year, their benefits will be terminated. If they're hospitalized, like an inpatient hospitalization for a year will cause a cessation. So these are all the different types of things, but we're really going to be talking mostly about CDRs and age 18 redeterminations today. So what is a CDR? So Congress, under the statute, subjects beneficiaries of both SSDI and SSI, so Social Security Disability Insurance Title II and SSI, to continuing disability reviews to determine if they remain eligible for SSI benefits. Typically, these occur every 3 years unless the condition is supposed to improve more quickly. There's some POMs, which I've cited here, which really talks about the differing times when people will be reviewed. For the most part, most people are reviewed every 3 years unless they have an impairment that is really not expected to improve, or a good example of someone who is reviewed more frequently would be a low birth weight baby, because children grow and will then not be low birth weight. These folks get reviewed after 1 year, and conditions like that are in that bucket. So what is the CDR process? When a CDR is initiated, what happens is, Congress will give Social Security a certain amount of money each year. they use that money to indicate how many CDRs they want to do. And then they, from that bucket, they tell each state how many they want to do. So say PA is told they get to do 15,000 CDRs this year. What they will start to do is pull the cases that are eligible for CDRs, so people who it's been at least 3 years since their last one, or if they're in one of those other categories, either 1 year or 7 years, and they will use a tool to determine what kind of form they want to send them. To people who they do not expect to get better, they send a 2-pager. It's a 2-page short form. It's the SSA 4455BK. And other people who they're not sure, they will send a longer 15-page form to get information about what's going on with them to see if they can assess whether they remain disabled. Now, these questions relate to employment, earnings, school, recent medical treatment, and that 15-page form, it also includes essay questions, like actual essay questions that they expect claimants to fill out about how they're doing, and as well as a medical release and any information about recent medical that Social Security can look at. That form is only available in English. After reviewing these forms, Social Security, if they need more information, they'll send people to a consultative exam. In Pennsylvania, those typically happen at IMA. It's really, really important for people to attend those exams, because if they attend those exams and the exam matches with the evidence they have in the file, in many cases, they will go ahead and just make a finding that the person's eligibility continues, and then they'll send the claimant a notice one way or the other. So another thing I want to highlight as far as the data, like I was giving before, that 75% of all people who go through this process are continued. So many, many people, if they fill out the form and go to the consultative exam, their benefits may continue without them really having an adverse finding against them. It does take a lot of work, though. As I said, you know, it's a big deal when you get this form. It's a 15-page form often that you're asking people to fill out on a fairly short timeline. Then, you know, hopefully your address is the same if you find out you need to go to one of these CEs. But if you get through those hoops, a lot of people's eligibility will continue. Now, if Social Security decides that your eligibility does not continue, you're going to get a notice that says that they're going to stop your benefits. You can elect benefit continuation if you appeal that notice and affirmatively ask for it within 10 days, 5 additional days for mailing. Now, I know many of you know that the mail is terrible right now and nobody's going to even get this notice in 10 days, which is something we've been raising with them. But this is something that you should be able to ask for. You also have 60 days to appeal, and you can seek good cause for either a late appeal or a late request for statutory benefit continuation through the next stage of appeal if you missed that initial 10-day cutoff for benefits continuation or 60 days for appeal. Typically, it's kind of hard to establish good cause, but there are a lot of, all of the offices have been told to give a lot of leniency right now during the COVID-19 pandemic. So if you do run into somebody who's, you know, maybe appealed but didn't ask for statutory benefits continuation, that's something you might be able to get them while they're waiting. So if you request reconsideration, it is a little bit different than reconsideration when you're on an initial Social Security application, because you get a hearing. That hearing typically occurs in a field office. Sometimes the disability hearing officer is there in person. Often they are there over videos. The claimant at this hearing can bring witnesses. They can bring a representative. There are no vocational experts, and the claimant has a right to appeal this decision if it is unfavorable to have another hearing before an administrative law judge. The same deadlines applies for appeal as at the earlier stage. Now, I want to note again that if somebody's benefits are terminated during a CDR, and then they affirm it on reconsideration, you can appeal again for an administrative law judge, and you can request again that their benefits are continued through that hearing. This is like a fairly long period of time when people's benefits can be continued while they are going through this appeal after their benefits have been terminated. Now, just like the Office of Hearing Operations, the Bureau of Disability Determinations, who are the people who run the hearings on these cases, the DHU hearings at the field offices, they have not resumed in-person hearings. Instead, these hearings are occurring over the phone. However, claimants have a right to object to these hearings, having them over the phone, and can ask to wait for an in-person hearing. And a claimant will continue to receive statutory benefit continuation through the in-person hearing if they elect this option. I want to highlight this because I know in my practice, I represent a lot of people who are facing benefit determinations who are in this posture right now, that they've had their benefits terminated. You know, they got a notice saying after the initial review that it was terminated, they needed to appeal, and now they're waiting for this hearing. You know, we've elected for an in-person hearing with benefits continuation. So many of them at the beginning of the pandemic, which has resulted in them getting continued benefits for almost a year so far, and possibly longer. It's definitely something to think about because it's not always an option available, but it does allow them to continue their benefits right now, which, considering that a lot of claimants are having a lot of trouble getting consistent medical treatment and all the other things they need to really make out their case, may be a strategic advantage in your case at the moment. Now, CDRs are subject to a different standard than typical SSI claims. It's the medical improvement standard. It's created by statute, which I listed there, 42 USC 423F. And the reason that this medical improvement standard is really important is it really prevents adjudicators from trying to second guess the initial decision. You know, just because the ALJ doesn't agree with whatever the ALJ did 10 years ago shouldn't matter here. If you can establish that there has not been medical improvement since the last time they were found to meet the disability standard, your client's case should be continued unless there's some sort of allegation of fraud or mistake or some medical breakthrough, which are rare.
Jen? Sorry, excuse me. We have a question for you. If the claimant elects to receive the statutory benefit continuation, could this lead to an overpayment if the benefits are terminated at the eventual hearing?
Absolutely. That's a good question. And that is something to think about and definitely to talk to your client about. So it can lead to an overpayment, but you know, you always have the option of filing an overpayment waiver, and the guidance at Social Security is very lenient toward granting overpayment waivers. That's where the overpayment was created because the person was receiving statutory benefit continuation while waiting for an appeal. So I think the risk of them being stuck with that overpayment is lower than it would be with a typical overpayment for like having too much income or having a part-time job or receiving a gift from someone. That's a really good question and definitely something to talk to your clients about when they're going through this process. So another thing that makes these the CDR standard, the medical improvement standard, really, really helpful is it prolongs the life of prior rules. Because the standard is medical improvement, we're talking about, the question is, has your client's medical circumstances changed since the last time that they met the disability standard? That is the same question, even if Social Security has changed its rules since that time. So a good example is asthma. As many of you know, in 2017, Social Security significantly changed the asthma listing. It used to be much, much easier to meet. It used to require 6 24-hour hospitalizations, but they would even consider like urgent asthma appointments to meet the listing, or a certain amount of corticosteroid prescriptions. Right now, you need 48-hour hospitalizations, it's almost impossible to meet. But if your client was put on before that time for meeting that listing, even if they do not meet the current listing, if their condition still has not improved from when they were previously found disabled, their case should continue under the medical improvement standard. The same thing with intellectual disability. 1205C, which doesn't exist anymore, used to be a much more favorable listing for our clients who were that qualified because they had some intellectual disability and some other impairment, right? They didn't have to meet the B criteria. That doesn't exist now. But if your client was found eligible on that standard, you can still use that in this context to make sure that they win. Other things that you should look out for, there's some listings that don't exist anymore, like the obesity listing doesn't exist anymore. But if your client came on for obesity years and years ago, if everything's the same, their case should be continued. Now, judges screw this up all the time, but it's something to look at. It also means that when you're evaluating your CDR case, you want to be thinking about, when the person was put on the first time and what rules applied, and go back and look at the old rules to see if you can use any of them to your client's benefit. Now, I kind of alluded to this a second ago, but in order to measure improvement, we need to measure it against something, right? So here, we're measuring it against what they call the comparison point decision, or CPD is what they usually call it in all the records. Now, the CPD is like the point at which it's the last time the agency found the person disabled. That could be the initial time they met the disability standard, or at a subsequent review, but the last time they made that determination, that is the CPD. And what is improvement? That's also in the statute. For adults, improvement only counts as improvement if it's work-related. So, if you have a client that maybe they've improved, maybe they don't, I should have thought through a good example of this. But so if you have a client who's an adult who has some improvement, maybe they got on for a seizure disorder and they still have a seizure disorder, but maybe things are a little better, maybe their migraine disorder went away. If there's no indication that their improvements would make it easier for them to work, then that's not improvement that matters. For children, it's a little different because they don't work. What the statute says is there needs to be improvement in the medical severity and that you can disregard minor changes. So, there's a lot of advocacy around what minor changes are. But so for both of them, you want to, what you're trying to argue about is whether there has or has not been improvement. And, part of how you determine that is how you frame it, right? For adults, even if there has been improvement, really try to think hard about, is this improvement work-related? And with children, could it be classified as minor? And if you can, using that framing can help you win a case to continue their benefits. So, as we said before, as I was saying before, and I just clicked ahead on this, so I apologize. I need to figure out how to click back. Just stop this for a second. Sorry, I just lost my thing. Here.
While you're working on that, Jen, I'm just going to read a comment that someone had put up after the last question. Just
Sure.
Noting that the other thing we have seen that we don't follow, the other thing we see is if they don't follow through with the hearing, they usually won't grant a waiver. So it's just a comment that someone had put up that I thought I'd read right now.
That's a really good point. One of the, and so we can talk, so So many of you may be familiar with doing overpayment waivers for your clients. There's two standards that you need to meet for that. You need to show that they pursued their case in good faith, and also that that it wouldn't be against the purposes of the act. So part of pursuing their case in good faith is that, you can say that, my client was pursuing this appeal because at every stage they believe they continue to meet the disability standard. And if they do not go to a hearing or do not go to something, that at least the agency has interpreted that to mean that they may not be acting in good faith and may not believe they continue to meet the disability standard. I think as practitioners, we all know that so many things come up in our clients' lives that would make them miss a CE appointment or a hearing. They might forget about it. They might not get notice about it. Somebody else might be sick in their family. But it is a good point that if you are going to represent someone on a waiver, you need to either, really press that they follow through with each step of the process by going to their CE appointments, meeting Social Security every time they call, or you need to be establishing a record for why not. So if my client doesn't want to go through a hearing in the end, I might be taking a declaration from them explaining, I have been proceeding with this appeal because it was my understanding that I continued to be disabled, which the reason Social Security tends to credit that is the person's already been found disabled by Social Security before, right? But sometimes to be like, after talking to my attorney, it's clear that I do not. So I'm, not going to go ahead with the hearing for the sake of judicial efficiency or whatever. And then they still may go ahead and grant the waiver. But if they just miss their hearing, that can be a problem. Now, a little bit more about the medical improvement standard. Again, you're looking at the CPD. The ALJ is supposed to be looking back at the prior decision and making their determination off of that, even if the rules have changed, even if the adjudicator disagrees. But part of the reason I'm highlighting all of these issues is many ALJs don't acknowledge this. And they don't acknowledge it because it's kind of outside their typical practice. Administrative law judges, by and large, are fact finders. They are at these hearings so they can meet your claimants, ask them some questions, listen to your questions, and then make an eligibility determination, right? In the CDR context, that's not what we're asking them to do. Instead, we are asking them to basically sit like appellate judges and look at what the judge found before and just answer a much more simple question is, has there been improvement? But a lot of ALJs really struggle with this. There aren't as many CDR hearings as there are other kinds of initial hearings. So it's really important that representatives are being pretty active at holding ALJs to the prior standards and to the looking at the prior decision and really looking at whether or not there's improvement instead of just trying to relitigate the case, because we have found over and over and over again that that is just not what judges tend to do. So now we've talked about this comparison decision point. What is it? All right. So the comparison decision point needs to be two things under the statute. It needs to be the most recent prior determination in your case. That can be a prior ALJ decision. That can be the DDE from the BDD adjudicator who made a determination, but you need to have that decision. It also needs to be every piece of medical evidence that prior decision relies on, all right? Every piece. So if that decision talks about a CE evaluation, that needs to be in the file. If it talks about education evidence, that needs to be in the file. All of those things need to be in the file, which is very important because if you have a case that you're not really sure how to win, one of the things I like to do is to go through that decision and see if it's all there. Because if it's not, that may give me some room as an advocate to advocate for my client. Now, I'm telling you, look at this decision, go compare it to what evidence. And you're like, where? Well, excellent question. This is one of the issues here. Where is a CPD? Sometimes it's included in the Section F folder. sometimes it's labeled the prior folder medical evidence, sometimes it's labeled CPD, and sometimes it's not exhibited at all, but in the file somewhere. But often it is not there, or it's not there completely. And by often, I mean probably more than 50% of the time. So you really should make it a practice to go hunting for these documents, understanding that there is a decent amount of time when you're going to discover they're not there, which gives you a nice procedural hook in these cases. So why is it missing? This isn't particularly important, but I was very interested in it because these are missing just so often. So the reason I have come up for why it's missing is that the Social Security's attitude towards these CDRs is that they literally mail files around a lot. So, you know, after Congress allots each state number of continuing disability reviews, the field office will get the prior file and physically send it to the Disability Determination Service, which in Pennsylvania is the Bureau of Disability Determinations, for initial determination. So they render a decision, they send it back to the field office, and if it's appealed, it's then sent back to the BDD, and if it's appealed again, then it's sent to the hearing office. So, you know, what I've noticed in my notes is if you go through the file, frequently, if there has been a cessation made, the adjudicator at the Bureau of Disability Determinations who originally made that decision, they had all the evidence, and they usually write these fairly detailed decisions explaining, you know, why they think benefits should be terminated. But for whatever reason, by the time the case gets up to the Office of Hearing Operations, like all of that evidence is missing. So somewhere in this little mail thing, they've lost a bunch of the evidence. But another good way to try to figure out what was part of the CPD is sometimes looking at those explanations, which are in the A section, to see what they were relying on. Because if they're not there, you know, again, that's a good hook. And so what do I mean by that? So the statute for CPDs is actually pretty fantastic when it comes to what's supposed to happen if part of the comparison point decision evidence is lost. So first, they're supposed to, the whole process changes and it's all laid out if you take a look at the CFRs. But the first thing they're supposed to do is evaluate whether your claimant can do substantial gainful employment. And if not, they're just supposed to continue the case, no more analysis. But if not, if they think that they can, you know, do SGA, then they're supposed to make a determination of whether the file can be found or recreated. And if they determine it cannot, the case is also supposed to just be continued until the next time your claimant is reviewed. So I just want to emphasize that and say that again. So if any part of the prior file is missing, even if the judge thinks your client can work right now, they're supposed to go ahead and continue benefits, and they're supposed to get benefits till the next time that their case is reviewed, and this will become the CPD. So, you know, procedurally, this is very protective because Social Security is, you know, the statute is very concerned about cutting people who have already been adjudicated disabled off. In reality, you know, claimants do not often hold ALJs up to this standard, but it is there. It is very, very strong statutory language that can help us, you know, make sure that our clients stay in benefits. And I really want to, I just can't point out enough how helpful it is to really focus on this in these cases. It can really help you win cases that are otherwise pretty hard to win. So Kelly sent out some materials, including this PowerPoint, but in addition to that, some letters. One of the sample letters we provided is a letter that's requesting the CPD evidence get added to the case file. This is something I routinely send at the beginning of the case. If I find that any of the CPD is missing, I send it right away to the judge. It sets out the statutes as to why they need to include it, that it's their job. The statute's also pretty clear that the onus is on Social Security to produce these documents, not you, and adds that if the evidence cannot be added, that the benefits cannot be ceased. This is nice because if and when you get to a hearing and the judge has still not added any of this evidence, it really tees you up for a very clean argument, while being like, sorry, judge, I told you that the CPD evidence isn't there. If we don't have the comparison decision point, obviously we can't talk about whether there's been improvement. As a result, you cannot cut off my client. Please continue benefits. And then if you end up in this situation, please contact CLS. We are always collecting these cases. Okay, so what happens if my client really improves? This happens a lot too. A lot of times my clients have actually just improved. There is clearly medical improvement. One example of a type of case that I do a lot is if I had a client who got on because they had, they were on dialysis because they were in kidney failure and they subsequently got a transplant. In those cases, it's hard to argue against medical improvement. There has been medical improvement. They got a new kidney. Things have improved to a certain extent. Similarly, if you have a client who got on because they had cancer and now they don't, that can be a kind of case where there's actual improvement. But if you can still establish, that doesn't mean you're out of the woods, though. You can still establish that other disabilities have happened, and SSA has to consider whether, if from the last point of eligibility, if there's new impairments, other things going on, whether or not they need to take that into account. Those new claims are evaluated under the traditional sequential evaluation process. For adults, it's steps 1 through 5. For kids, steps 1 through 3. So I want to talk about the data again. I know I said this at the beginning, but I think it's really interesting. The PAN national data in 2020, we just got these numbers recently, for the continuance rates of CDRs after an initial review is 75%. So most people who are reviewed are going to go ahead and get continued. They're not going to need a lawyer. This is just something that's going to happen. But for those people who are not continued, they're going to face these cessations typically without representation. Only 5% of them have any representation when appealing CDRs before the BDD, and only 17% of them end up with representation, before they have hearings on the ALJ level. This is really problematic because, as we've just discussed, the cessation process is pretty complicated, right? Not only are they looking at losing their benefits, which is already a very stressful situation, but this appeal process uses an entirely different standard, the medical improvement standard, which also requires an understanding of whether or not there's comparison decision point evidence in the file, right? This standard and the need for a CPD are things that unrepresented claimants are not going to know about, and they're not going to be able to enforce those rights. And as we've already discussed, ALJs, this is kind of counter to what they do. So most ALJs aren't thinking about this either, which means that in a lot of cases, people will be ceased, even if you really look in the case, there's pretty strong evidence that there hasn't been medical improvement. Also, of those 25% that are terminated, not all of them are terminated because they've gotten better. A lot of people are terminated because they weren't able to provide the evidence that Social Security requested through the review process. But just, another quick point of review, how Social Security does this is they send out a 2-page or a 15-page form in English and ask you to fill it out with all your medical advice, all your medical information, including essay questions. A lot of people can't do that. And even if they can do it, a lot of these letters go to old addresses, maybe a completely wrong address. Maybe the client just wasn't there. It's only in English. Maybe the client didn't know that the claimant didn't know that they need to take this to someone to have it read. So there's a lot of reasons why people get ceased that have nothing to do with the fact that they have medical improvement. And a lot of it has to do with how this process happens. Another example, which I can take from my caseload, is I had a client who was put on disability for being schizophrenic and also having an intellectual disability. And in part of the original case, the evidence showed that as part of his intellectual disability, he also had a lot of trouble reading. So Social Security knew, based on their own evidence that they used to make a finding of disability for this claimant before, that this gentleman could not read. Yet they still sent him a 15-page form that he needed to fill out in order to continue his benefits. Y'all can probably guess what happened. He certainly didn't, he first of all didn't get the form because he'd been homeless, because he'd been off his meds and schizophrenic. But when he did get it, he didn't have anyone read it until he finally took it to his sister about 120 days later, well after the appeal deadline and just after his benefits were ceased. So this isn't a perfect process, and a lot of people are going to be left out, which is why it's really important for people to get involved. So we've talked a lot about benefits continuation. I'm just going to say it again. At each stage of this appeal, people can get benefits continuation, and it's important to help them do that, or at least make sure people know about their rights. You have 15 days after the initial notice that your benefits are going to be stopped to ask for it. But they, particularly right now, field offices are being pretty reasonable about giving good cause. If you're saying that you're getting these notices late or weren't able to, ask for them in time because it's hard with the field office closures. And if your client has, they go up to an ALJ decision and they get benefit continuation the whole time, in some cases the ALJ will then also affirm the cessation. If you take it to the appeals council and get it turned around, benefit continuation should be restored. So just know anytime your client is waiting for a hearing up until the ALJ hearing, you can get them benefits continuation if this whole thing is an appeal of a cessation.
Sorry,
yes.
This is Kelly. For the attorneys on the call, I'm going to launch the first of the two CLE question boxes. And Jen, I'm getting a number of comments on the chat box. Your PowerPoint still isn't up since you took it down, and people are wondering if you could put that back up so they can more easily follow along.
Oh, I'm sorry. I've been looking at it. I thought it was up. Do you see it now?
Yes, it's actually
okay.
In the slideshow. You want to put it, because we can see your next slide in your notes right now.
Okay, I'm clearly failing at this, guys. Sorry.
It was good before. I don't know if you have two screens. You might want to switch the screens or.
Sure.
I also dropped it in the chat box so people could easily open it now on their computers too.
Hold on.
So for the CLE question poll, the first one, we'll leave it up for about a minute more. Attorneys, if you're requesting CLE credit for your participation, please go ahead and respond either yes or no to the question. Jen, when you click share screen, are you able to choose the screen that you want?
I've actually lost the whole Zoom call. I'm sorry, just hold on a second. I tried to move it so I was looking at you guys correctly, but now
if you look at the
okay, here we go.
Yep. Yeah, the blue video camera button should bring you back.
Thank you.
Sure.
All right. All right, can people see it now?
No, we just see your video. Got it now.
Perfect. All right. I'm so sorry about that. So now we're going to talk about age 18 redeterminations. So like CDRs, these are mandated by statutes. Every SSI childhood beneficiary is mandated to be reviewed at age 18 to determine whether they meet the adult standard of disability. I want to highlight that 73% of recipients lose benefits at this step, and more people lose benefits at this step in Pennsylvania than they do nationally. So age 18 reviews and CDRs are a little different than each other. So first of all, in age 18 reviews, there's technically no medical improvement standard. So instead of looking at improvement, it's really a new determination about whether or not this person who has previously been found disabled meets the adult standards. So it is more like a traditional SSI case, but there are some differences. There's also note that parental income is no longer a factor. So there are some people who become newly eligible at 18. The same procedural steps happen as a continuing disability review. Social Security will initially send out a mailer to the family, and you fill it out, and they'll take a look at that to get some information before when they start the review process, and then you'll go through an initial determination. Then if your benefits are ceased after that, you can request reconsideration. And similar to a CDR, at reconsideration, you are entitled to a hearing before a disability hearing officer. And just like in the CDR context, you have a right to do that hearing in person in the field office, and you can object to that right now and have benefits continuation throughout that entire time. If you lose at that disability hearing officer hearing or that DHO hearing, then you can appeal again and go have an administrative hearing with an ALJ. And throughout that entire period, you are able to get statutory benefits continuation if you request it within 15 days of the termination notice. Now, one thing that's different about these is Social Security ruling 11-2P. I know many people on this call love Social Security rulings as much as I do. If you are not one of them, I highly recommend you at least look out for this rule in particular. SSR 11-2P is extremely helpful in this context. It essentially creates a medical improvement standard for young adults. So it governs all cases with young adults, approximately ages 18 to 25. It provides that relevant evidence in these cases includes school records, extra help, accommodations, and supportive settings. Now, if you're somebody who represents a lot of children, this will seem very familiar. There's a lot of other rulings related to establishing disability for children under the 6 domains of functioning that talk about the importance of things like school records and whether you're accommodated and do you have an IEP, all of which is super helpful evidence and also has lots of functional information. There isn't an equivalency for adults, right? There just isn't an emphasis on this. But with SSR 11-2P, this policy tells adjudicators that for young adults who are facing terminations after getting SSI as a kid, you need to look at this stuff. It also has a very helpful language about the occupational base and in what circumstances it's eroded. If you don't have the 4 basic demands of unskilled work, which has to do with understanding, remembering, and carrying out instructions, making simple judgments, responding appropriately to supervision and coworkers and changes. So very useful language as well if you have a client who did meet the childhood listings, but maybe doesn't squarely meet the adult listings because they're a little bit different and you're trying to make an argument in between. It also explains that a finding that a child had marked or severe impairments in the 6 domains of functioning is highly likely to mean that they meet the B criteria. So that's a lot of technical language, but it basically means that SSR 11-2P says this prior finding that the child was found disabled is very highly relevant in this initial determination for them as an adult. And it forces the judge, if you force the judge to follow it, to really take a hard look at that evidence, which can be very helpful. Now, related to this, I want to talk about Section 301. I know you guys that we aren't doing, but can people, use an emoji or something or make some indication if they've used Section 301 in any of their cases? All right. Oh, looks like Deborah has. Awesome. So this is a really helpful section. A few other people as well. Jamila Tucker. Awesome. So Section 301 basically says that in certain circumstances, even if Social Security determines that someone no longer meets the disability standard, if they are in a program, like a vocational rehabilitation program, and it meets a bunch of very, very strenuous requirements, but if they're doing that, that they can continue to get benefits until they are done with that program, right? So basically, this is a wonderful safety valve for certain clients who are in the process of getting off disability benefits to allow them to continue to get that support while they get the vocational support that they need to rejoin the workforce. It's really hard to establish Section 301 eligibility, really, really hard. And part of the reason it's really hard to establish this eligibility is because Social Security's own internal processes are not well designed to allow this to happen. But I wanted to alert this for all of you, because if you do start getting into these cessation cases, this is exactly the kind of circumstance where this might come up. You have a client, they have been getting SSI for a really long time. For example, I have a client, I'm going to go ahead and call him Tom. I've had him for years now. He got SSI as a child. He probably has an intellectual disability. It's a little hard to tell. He did have an IEP because he had a learning disorder. He has had some mental health diagnoses as a child, but as a young adult, he decided he was no longer interested in treatment. And so after he went through his age 18 determination, I represented him at a hearing where he sat there and explained to the judge in no uncertain terms that he felt like he could work and that his mom was the only one pushing this benefit stuff, right? So, not the best hearing I've ever been to. There wasn't really much I could say about that. But, he had been in IEP all through high school. And before they even sent out his determination, he had hooked up with the Office of Vocational Rehabilitation. And they had evaluated him and determined that he would need services, like he has a qualifying disability, he would need services to join the workforce. And he had started working with them. And he continues to work with them. So even though we lost his case, I was like, I think we can continue his benefits. And we were able to establish that. And he continues to work as a home health aide for a family member, right? So I think there's an argument that it's not really competitive employment. But, he does have some income and he is working with these supports, but he's also continuing to get SSI because he is getting treatment and they're working with him through a variety of ways. I think there's therapy, there's some portion where he's working with a work supervisor in order to see if he might be able to work in a competitive setting at some point. So here are the requirements, and this is why it's hard. So you need to participate in voc rehab, but I will point out that at least for that IEPs count. So if you have a client who's had an IEP, that whole period counts. But you needed to have started working with vocational rehab prior to your cessation. That's the part that gets tricky, is if you have a client who didn't have an IEP, but was getting SSI and maybe other supports in school, and they got their cessation, say when they're 19, and around that time, they connected with voc rehab because maybe it took them a while to connect, they didn't really know about it, whatever, they may not qualify for Section 301. This timing aspect is pretty challenging, particularly since the Office of Vocational Rehabilitation, at least here in Philadelphia, is very, very overwhelmed, and it can take a really long time to get an intake. But so you need to have started participation in whatever program you had before you were ceased. And then Social Security needs to determine that you completing this program will in some way increase the likelihood that you will have to, that you will return to the disability roles in the future. Now, before I go on, does anyone have any questions about that? Okay. Now, how does this work then? So how this works is, you know, somebody who is getting benefits, you know, like my client in this case, Tom, gets a cessation notice. So in this case, the cessation notice would have come from the administrative law judge. After that, in order to establish Section 301 eligibility, you need to have whoever is the person providing vocational rehabilitation services, which could be the IEP provider at school, or if they have voc rehab, they're supposed to fill out a form which goes into SSA. When Social Security receives that, they're supposed to take that information, and the field office cannot determine whether you get Section 301 eligibility. Baltimore has to. So they have to send it to Baltimore for an assessment. But what we have found out, one of the problems in these cases is that typically after you get a denial notice, there is no longer a claims representative assigned to your case. So there's nobody reaching out to the claimant to be like, oh, do you happen to be enrolled with voc rehab? And if you do send something in that would suggest you'd be eligible, either the form that Social Security wants or something else, there's nobody looking at the case to make that determination. So, you know, I've never heard of a client who's been able to meet Section 301 eligibility who didn't have a attorney representative or case manager or social worker involved to draw Social Security's attention to that case. But if you do get that paperwork in, you are able to get continued benefits until Baltimore makes the determination, which can take a really long time. And then your client gets to keep benefits until they're no longer participating in the program. And, you know, just to point out the same client, Tom, it's now been 15 months since we got it established that he had Section 301 eligibility, and that was a solid year after I lost his case. So his benefits has continued for at least 2 additional years already, which is fantastic because he needs the support. And, you know, he in particular is a client who I think eventually is going to end up back on SSI. But this does offer, you know, a really nice opportunity for your clients who, you know, do want to try working for a while and maybe can, with enough support, get off of SSI or SSDI in the long run. So it's something to think about. And whenever I am representing age 18 clients in particular, I like to ask, you know, have they been involved in the Office of Vocational Rehabilitation? Many people are. They're supposed to be at IEP meetings. So sometimes child clients will have gotten involved in them, you know, when they were in high school and maybe not even know it, to see if there's some room here. So something to think about when you're dealing with cessation cases in order to keep your clients' benefits on longer.
Jen, we have a question. What if client is on waiting list for vocational program?
That is really hard. It's a really, really, really good question. So have they done an intake, or do you have any proof that they are on the waiting list? Because if you do, we have been trying to do some advocacy around this. I think you have an argument if they're on the waiting list for the program before they are ceased, that you might still be able to make the Section 301 case out. But it's only if they were involved before then, because there is an understanding that that there is a long wait list. Another thing you can do if you have any ties to your local voc rehab office, is sometimes I will reach out to them and say, you know, I understand my client's on a waiting list. You know, have they done an intake? Social Security will accept proposed plans, like likely plans of what they're going to get to make these determinations. So sometimes based on the intake, you can get the person at voc rehab to fill out Social Security's form indicating what the plan is, and that will be enough.
And she responded yes from OVR.
So I would see if you can contact that OVR rep and see if you can get them to complete the plan form, because that's what Social Security needs. They have this form that you need to fill out saying like what the plan will be, but a lot of claims reps know that it can be kind of the hypothetical plan is enough if it's clear that they're probably going to provide services.
That's all we have for now.
Okay. Now, so some of the other things to note in this context is that during, you know, that when you have a CDR or an age 18 review, Social Security ruling 11-1P does not apply. So that's the Social Security ruling that says that, you know, if you appeal to the Appeals Council, you can't also reapply at the same time. That does not apply here. So if you are representing someone on a continuing disability review and they've been ceased and you're appealing that cessation, you can also ask them to go reapply and start a new claim at the same time. Same thing with an age 18 review. So it's a new initial claim, it's a new case, but they can go on at the exact same time. And I would, now field offices often ignore this policy and will frequently tell your clients if you send them in, which obviously no one's sending them in right now, but you know, hypothetically, they will tell your clients that no, you can't go ahead and start a new claim. I can see you have an appeal here. They're wrong. I mean, I've even had in one case, I sent my client in with a letter, you know, with the language from 11, you know, explaining that this is a client, we're representing them on appeal of their cessation. You know, the Social Security ruling 11-2P makes explicitly clear that you're allowed to reapply when you're appealing your CDR. Sent them in with the letter. The claims rep gave my client a letter back to give me, explaining that they cannot reapply. They can only reapply in these circumstances under 11-1P, including when your appeal is based on a cessation. So they like gave me a letter back that said the exception they fit under and sent them away. And we had to get the district manager involved to allow them to take the initial application. So I just wanted to note with that there is some pushback there. Recently, I think in August, regional, for at least the Philly regional area, sent out a notice to all the field offices reminding them that people are allowed to reapply if they have appeals pending on their cessations. They do not need to have a new medical opinion condition to do that. I've also heard that from lots of claims reps being like, oh, you can reapply while you're appealing a cessation, but only if you have like a new condition. No, that's not required. This isn't substantive, right? There's no substantive reason you can reapply. It's procedural. Like if you are appealing a cessation, you can also file a new application at the same time. And the benefit can be that if you win on the new application, that's obviously very persuasive on your appeal of the cessation, depending on the timing of the claims. It can also be helpful for your client just to keep them in benefits, right? So if they they don't lose benefits while you're litigating the appeal. So I always urge that my clients reapply while I'm appealing if I think there's any merit or basis to it. So I encourage you to do that. Just know that I often have to get involved at the field office while I'm doing it to make sure that new application goes through.
Jen, we have another question.
Sure.
If a client reapplied and is approved and then wins their AC appeal, what is the relevant period for the ALJ remand hearing? I have a client in this situation and the hearing notice stated that the relevant period was through the present. Is our ongoing eligibility at risk?
So maybe. So typically what happens when they remand, if you have a termination, you go to the AC, they remand it, it usually is through the present. If there is another pending application that they've won on, sometimes or often, if the appeals council knows about it, they will usually comment about the period. Sometimes they will affirm that new initial in their remand notice. If they have not, then yes, the ongoing eligibility is technically at risk. Though I find most of the time that the more recent eligibility is actually a persuasive point to just winning the whole case. But you'd want to really talk that through with your client, particularly if the issues are different. I was recently advising someone who was representing a client who had a very, they had fought really hard on a SOAR application that was recent, I think from 2020, to get a client on, but they were also still litigating the past CDR, and there was no treatment for like 6 years. And so they ended up, they had a strong CDR case, but they ended up walking away from it after the AC remand came back because they were concerned. The client was so concerned about just keeping the current benefits, and there was significant risk there. So I would think through that. It is definitely at risk. So as I said, sometimes when you do it, when the appeals council sends it back, they'll make note of the initial, and on occasion they will, in their remand order, like affirm the new claim, which is helpful, and instead make it a closed period.
That's all
Is
the
there
questions.
anything else on that?
Nope.
Okay.
That's it. Thanks.
So the next thing that I want to highlight for people, which makes me very happy, is in the CDR at age 18 context, the 5-day rule does not apply. So in the letters that Kelly circulated, another letter points that out to judges. I like to send a letter saying, under 17-4P, we're supposed to tell you everything 5 days in advance. Although my office is going to do everything we can to comply with this, I just want to point out that in the cessation case, the 5-day rule does not apply. It does not apply at all. The 75-day notice that goes with the 5 days also doesn't apply. They only have to give you 20 days notice, which is something just to remember. But the 5-day rule doesn't apply, and you are allowed to continue to submit evidence in those cases up until the date of the decision. So, can be useful. It definitely takes the onus off. It means you can turn in your pre-hearing statement whenever you want, and the judge has to consider it. They don't get to exclude it, which I enjoy. Now, we've already talked a little bit about overpayment issues. I want to circle back to that, because overpayment issues are, they're pretty significant in this area, because obviously if people's benefits are being ceased, if they're requesting statutory benefit continuation while they're appealing, as was already pointed out, they're going to get an overpayment if they lose, which is a problem. But so the other problem that comes up a lot is that they will get notices of actions for overpayment even when they're still appealing, right? So if you are ceased and you get statutory benefits continuation through the DHO hearing and then through the ALJ hearing, if you lose that ALJ hearing and you decide to go to the appeals council, you're not supposed to get an overpayment yet. Under the statute, you are not, and the regulations, they're not supposed to start any overpayment action until all your appeals are exhausted, all the way up to district court. However, we find routinely that our clients are getting these overpayment notices. And not only are they getting these overpayment notices, in cases where we've gotten the client on a new claim, some of our clients have been paying down these overpayments through withholdings of 10% or $10 a month. Some people have had their tax returns, taken to repay overpayments that are premature and should not have been applied yet because they're still appealing. We had one client whose Social Security reported to a credit bureau on a premature overpayment. So this is a big problem. It's something that CLS initiated litigation about, and Social Security is looking into it, and they are trying to resolve it. But I want to really, make sure that people are aware that these premature overpayments are coming out, and they're coming out frequently. We're not really sure why. We think it's like after the ALJ decision, there's some sort of like automatic trigger to send out an overpayment notice that for whatever reason isn't sensitive to whether or not there's been an AC appeal. But you should look out for it. And another one of the letters we included is a protest letter. And that is just a quick letter that you can send to the field office saying, my client had a cessation. You sent out this notice of action for an overpayment. However, we're continuing to appeal, is basically what it says. And in a lot of cases, we have found that that is enough to get the field office to say, oh, right, you're right. And then they stop the overpayment action. However, one of the problems is even though they stop the overpayment action, sometimes they don't successfully stop all the letters, and our clients still get those really scary letters saying you owe, $17,000 and it's due in 4 days, which at least concerns a lot of my clients and induces a lot of unnecessary anxiety. But so, they really should not be facing these overpayment issues while they are appealing. And if you see this, please send in the overpayment protest letter and contact CLS. We are continuing to collect these cases. We think this is a nationwide issue. And it's really problematic, particularly, in the case of a client who had, and I guess it's 2 clients who had Social Security report to credit bureaus, like their other financial things in their life were impacted by these premature overpayments, which is a problem. So I've said a lot of things about what to do in these cases. I tried to kind of summarize them as on this slide with practice tips, which is, remember, if you get a cessation case, one of the first things I always want to do is think about, whether they're, which rules don't apply. You want to remember that if my client is ceased, I can go send them right away to file a new application. I can remember that the 5-day rule doesn't apply and send in the letter that reminds the judge of that. Remember that my client is able to get aid paid pending throughout all of the appeals up to the ALJ level, and you should at least be having a conversation with your client about whether they want that. If your client did the appeal themselves before you got involved, the Social Security meetings where they talk about statutory benefit continuation can be very discouraging. A lot of the claims reps really, really focus on the fact that there could be an overpayment and scare your clients out of getting this money. For the most part, if somebody has already been found eligible once, it's going to be fairly easy to win the waiver. So I think, letting your client know that if you get this money, you might, if you lose, have an overpayment, but we could probably also just do a waiver and get rid of that. So there's not that much risk of this affecting you financially down the road. It's an important thing to bring up. And particularly now, since you can continue that statutory benefit continuation for a long time, a lot of people have gotten a lot of support during the pandemic by just staying on these benefits. Always request the CPD and look for old evidence. Always make sure, whether or not it's there. Check to see if prior listings apply. If you have an age 18 case, take a look at 11-2P. There is so much helpful stuff in there. See if you can apply it to your case. And if you have a client who, it's a cessation, you always want to see if they are involved in voc rehab or OVR. So if you lose, you might be able to get them statutory benefit continuation in the end. So I wanted to give you a couple updates. I've done this training a bunch of times, and the first updates I want to give is about COVID-19. So Social Security stopped working on CDRs completely in March, and then they resumed them in August. So you may have seen a lull in CDR cases, and then all of a sudden kind of an onslaught of people that are being ceased and coming to your office for help. That's why. We've talked a little bit about this, but there's no reason why your clients need to lose benefits right now, at all. And there's a lot of reasons why you don't want to have your clients, go through a DHU or ALJ hearing right now, because a lot of our clients haven't had access to the same level of medical treatment that they had pre-pandemic, and those who are in treatment, I don't know if you've been looking through therapy records from your clients, but phone therapy is just not as illuminating as in-person therapy records, it's a lot harder to prove cases. So, if your claimant's benefits are ceased through to a CDR, you might want to really think about and talk to your client about whether they are interested in objecting to any sort of audio or video hearings and waiting for an in-person hearing so that they can, just collect statutory benefits until after the pandemic and you guys can reconvene when everything looks a little bit more like it used to. So just things to think about. I say audio and video because if you guys haven't heard, in May they're going to start video hearings at most of the OHOs. So even if you've elected for in-person hearings and have rejected the phone hearings, you're going to have to do another round of talking to your clients about whether they want to object to video hearings. Though I don't yet have any information on how the video hearings would work, particularly like, would your client be able to be on a call like from their phone while you're somewhere else? I don't know. Another update is, last year I talked to many of you frequently about Social Security had a problematic proposal in the Federal Register where they were going to change the CDR program and they were going to make it so many people were reviewed more frequently. Instead of every 3 years, it would be every 2 years. And they'd also be doing just far more reviews a year. There were a few other big changes. They were going to, for people who don't have expected medical improvement, they would have been reviewed every 5 years instead of every 6 to 7. And then they were randomly going to review all kids at age 6 and 12. No particular explanation for why, really. So this was something that drew a lot of opposition. There were 125,000 comments on the Federal Register, the notice of this proposal, almost all of them negative. There were critical stories in the Enquirer, Forbes, the Tennessean, on Fox. There were a bunch of senators had a big event outside Social Security. There was just a lot of action around this proposal. And despite that, all of that negative action, late November, Social Security sent it to the Office of Management and Budget to see if they can push it out as a final review. I am pleased to say that in January, they withdrew this proposal completely. So now this proposal is gone and CDRs will continue as they have been mostly every 3 years for most of our clients. So I know we have another 10 minutes. I just want to ask, does anyone have any questions? I've really been appreciating the questions throughout the presentation.
I'm going to give time for people to type their questions in the chat box. And in the meantime, I'm going to launch the second of the 2 CLE box question polls. So attorneys, please feel free to respond to the poll. You must do so in order to earn CLE credit. And anyone with questions or comments, please type them in the chat box now. I know people are responding to the poll and maybe typing some things at the same time. So we'll give another few minutes to see if there are any questions or comments. Not seeing anything so far. So I'm just seeing a thank you for taking the time to do this session, but I'm not seeing any questions. Jen, did you have anything else that you wanted to add at the end or say?
I think I'm good. Just thank you everyone for joining. My understanding, Kelly, correct me if I'm wrong, is we're within the window that we're allowed to end early and still get all of our credit, right?
Yes,
So,
yep, we're good. Actually, we do have a question. We have a question now. Do you have any experience with a child being cut off for misuse of funding?
maybe. I was going to say, I definitely, do you mean maybe? And Michael, maybe if you want to talk a little bit more, I definitely have cases where they believe that the parent is misusing the funds. And sometimes you have to, I mean, there's a bunch of different approaches, I'd say, but yes, we've had to deal with that on a few occasions. We've also had some situations where the parent has been accused and is not able to rebut issues with misusing dedicated account money, which can be a little tricky.
Okay, that's all I'm seeing. So Jen, thank you so much for being here with us today and for sharing all of this information with us. Thanks to everyone who joined us. We have 2 more sessions of the DAP, SSI, SSDI trainings next week on Tuesday and Thursday at 2 o'clock. Tuesday is step 5 overview, RFC grids intro to VE cross-examination, and the 18th is VE cross-examination role play exercise with breakouts. So if you haven't already registered, please sign up for those to reserve your place. Not that it's limited, but okay, everyone, you have a great weekend. Thanks for joining us. Thank you, Jen.
Bye.
Take care.